And for whatever it's worth, if you're
Mike.
comfortable, I have a guest room and I'll feed you. And
Ooh, big boy.
Yeah, I've been there. I've been there.
Say that again.
I said, you're going to climb in bed with me too?
No.
No, I said I had been there at the Macro Hotel, and then right after I said that, you said climb in bed too, and I was about ready.
I should have had like everyone that stays there sign the bed. I think it'd be funny because there's been a lot of
check mark in the headboard.
Yeah, a lot of big people have stayed in my guest room. That's for sure.
Meet the Pressers with Matt Mallory and Klint Macro. Brought to you by Public Safety and Education and the Trigger Pressers Union.
This episode is brought to you by Steel City Ammunition. Can't find ammo? We've got it. We'll ship it and our prices are fair. Mountain Man Medical. The right medical training and gear should be accessible to every American. Mantis. Mantis X helps shooters suck less. Meet the Pressers is also generously supported by other fine companies, ranges, and our Patreon members. Thank you.
Hello, this is Meet the Pressers. I'm Matt Mallory, and this is my awesome co-host, Klint Macro, right here. And we talk about trigger pressers, pressing triggers, guests on the show, talk about political activism, church, occasional gear review, blow things up, all that fun stuff. And we have a phenomenal guest today that's been this is his second time on the show, and we wanted to let Klint go ahead and introduce this great gentleman.
Well, I'm super proud to introduce our guest. His name is Joshua Prince, and Josh is one of the state's, definitely the state of Pennsylvania's preeminent Second Amendment attorneys, and quite possibly one of the greatest Second Amendment attorneys in the country right now. And the work that you've done here in the Commonwealth is amazing. I truly believe that God puts people in places at certain times in history for a reason, and I believe you're here for the liberty of Pennsylvanians. And I thank you for coming on the show, Josh.
Amen.
Clint, that's very kind of you to say. I don't know that my head will fit through the doorway after all those compliments. That's very kind, but it is an issue that's true and dear to my heart. And I think that's one of the main reasons why I've had the success that I've had. Is this isn't just an issue that I could care less about. My clients aren't just simply numbers to me. Rather, I litigate every single case like I was litigating a case for myself. And that does take a toll on an attorney. Any attorney who tells you differently is lying to you. But quite honestly, I couldn't see myself litigating matters any differently. That's just who I am. And this issue is so near and dear to my heart that I wouldn't have it any other way.
We definitely appreciate that. And you've had a lot of successes over the last couple of years here in Pennsylvania, especially with preemption cases. There's a couple that are still in limbo right now because they've been appealed. Do you have anything you'd like to offer on Harrisburg or Pittsburgh?
So yeah, we have a couple cases that are pending. We also have one in Philadelphia. So I'll kind of bring everyone up to speed on those cases. The first, I guess I would address is the Harrisburg case. That case initially was dismissed. It's actually the only preemption case I've ever lost in the courts. Judge Dowling in Harrisburg, basically in Dauphin County, dismissed the case, and we appealed up to the Commonwealth Court. The Commonwealth Court reversed Judge Dowling, finding that yes, we did have standing to challenge all of those ordinances. Thereafter, the city appealed up to the Pennsylvania Supreme Court. The Pennsylvania Supreme Court agreed to hear the case because when you appeal to the PA Supreme Court, generally it's not by what we call right, meaning you don't have a right to have them hear it. It's only discretionary if they want to hear it. And in this situation, the PA Supreme Court agreed to hear it. We went through briefing about, I think it was in October or so, we had oral argument, and that went extremely well. There were a number of questions from justices like Justice Weck that were basically saying, how could you basically not have standing to challenge a constitutional right? And what the city was arguing is that it would just open the floodgates to litigation if God forbid they could be sued over illegal ordinances that they've passed and are enforcing. There's no dispute that they are enforcing them.
Wow.
And yet they contend we don't have standing. Justice, like I said, Wecht had made a bunch of promising statements, as did Justice Donahue. And I do think we will see a decision from the PA Supreme Court in the near future, probably within the next 6 months, that will affirm the Commonwealth Court's decision. And it'll actually be an issue of first impression, because as we sit here today, in relation to any constitutional right, there is no case law from the PA Supreme Court on what is necessary to aver, or basically state in a legal pleading, for purposes of standing when it involves a constitutional right. So whether it be your freedom of speech, your right to keep and bear arms, all of those different constitutional rights, right here as we sit here today, there is no binding precedent from the Pennsylvania Supreme Court when you file a declaratory judgment action as to what you must be able to show to be able to challenge it. So hopefully, like I said, in the next 6 months or so, we'll see a decision there. We also have the case pending against Pittsburgh. In that situation, as probably a lot of the listeners know, Pittsburgh passed 3 overarching ordinances regulating everything from what they deemed to be assault weapons, which also included handguns, to high-capacity magazines, to also regulating extreme risk protection orders. We filed challenging all 3 of those ordinances in total. There was a separate case backed by NRA that only challenged one provision of one of the ordinances. Anyway, we had litigated that case, and we were successful in the Allegheny County Court of Common Pleas in getting all 3 of those ordinances in total ruled unlawful and enjoined. Thereafter, the city took an appeal up to the Commonwealth Court. Again, we had oral argument, I think it was back in October. And with the Commonwealth Court, I would expect that we will probably have a decision anytime now. The court did hear the case, what we call en banc, meaning in front of the entire court. And that means that any decision that comes out of the Commonwealth Court will have the most binding precedent possible from the court. And we expect, again, based on all the questioning during oral argument, that the Commonwealth Court will affirm the trial court decision. It was actually quite telling, because after many of the Commonwealth Court judges skewered the city attorneys and those from every town law that's representing the city, I only got one question. And it was a Biden softball question type, where they basically asked me, so Mr. Prince, am I understanding you that you're basically arguing that all 3 ordinances are preempted by state law? I said, yes, as I've kind of just already reviewed. Okay, that was it. That was the hard question of the day during oral argument. And then, so with that, we could potentially see a decision any day now with the court. I don't think they're going to delay it too long, but again, there is no time frame in which a court needs to make a decision. So we could be looking upwards of 6 months, but I don't think that's likely. The last case that we have pending in relation to preemption is the Armstrong case. That's out of the city of Philadelphia. There, although it was a decade ago that the city passed a lost and stolen firearm ordinance, they recognized that they couldn't enforce it because it violated preemption. And in fact, 2 prior district attorneys in the city of Philadelphia stated that it was unenforceable because of preemption. Nevertheless, last year, the city all of a sudden, with the approval of District Attorney Krasner, decided that they were going to prosecute someone under this ordinance. And they basically expected that because the fine was only, as they said, $2,000, that the individual, Mr. Armstrong, wouldn't obtain counsel and wouldn't challenge it, and that they would be able to go on, not be hamstrung by any litigation in the future over the unlawful nature of the ordinance. Well, thankfully, Firearms Owners Against Crime and Firearms Policy Coalition stepped in, and they retained me to help Mr. Armstrong. And unfortunately, we filed for a permanent injunction. And the court denied the permanent injunction without any explanation. That case we've appealed up to the Commonwealth Court. So again, listeners know one of the reasons why I contemplate filing either preliminary or permanent injunctions is because, unlike everything else, any ruling on a request for an injunction is immediately appealable. So while the case is basically still pending in front of the Philadelphia Court of Common Pleas, the denial of the injunction is immediately appealable, and we have appealed that up to the Commonwealth Court. I actually have all of our briefing all ready for that. So as soon as the Commonwealth Court gives us a briefing order, I intend to file our briefs and move the case forward swiftly. The city has agreed to stay the enforcement of the lost and stolen ordinance until we have a final determination in this matter. And the Commonwealth Court previously reviewed a lost and stolen ordinance. In fact, the city of Philadelphia's lost and stolen ordinance back in a case called Clark, and they found that it was unlawful. Yet the city is enforcing that basic same ordinance today.
Well, preemption, essentially, the very layman's explanation of it is that a city or municipality can't pass a law that supersedes any law that the state legislature passes. Right. But unfortunately, here in Pennsylvania, there's really no teeth in that, because these folks do this, break the law.
Don't even care. They
get beat in court, and it's the individual or the person that was damaged, or Firearms Owners Against Crime, or Firearms Policy Coalition that are out the money to get that right back. So right now, there's a couple bills that are coming up in Pennsylvania, strengthening preemption. If we can get some teeth behind that, meaning that if those elected officials do violate the rights and liberties of law-abiding Pennsylvanians, then they have to pay for it. There has to be some consequence.
I completely agree with that. And I am trying to be able to get some attorney's fees in two cases. I didn't mention this, but Allegheny County Sportsmen's League had filed also a separate case against Pittsburgh. Theirs was based on a prior settlement agreement where, in relation to ordinances they had passed, I think it was back in '94, the city of Pittsburgh entered into an agreement when Allegheny County Sportsmen's League sued them that they would basically not enforce those ordinances and they would not violate Pennsylvania law ever again. That case, we filed for contempt of both the settlement agreement and the court order approving that settlement agreement. And under contempt, there is an ability for the court to award attorney's fees and costs. In the Armstrong case, we are going to be asking the Commonwealth Court to determine whether it should award attorney's fees and costs because of the fact this ordinance is verbatim the prior ordinance that the Commonwealth Court reviewed and found to be unlawful in Clark, and yet now they're trying to enforce it and basically trying to see if the court agrees with us that this is just so obscene, so frivolous that attorney's fees should be awarded. But absent those types of arguments, you're absolutely correct that there's no ability to get any form of attorney's fees, costs, or anything for anyone who's aggrieved, including Mr. Armstrong, who's having to pay money, in essence, to fight against an illegal ordinance. And the other frustrating aspect of this is that under our Uniform Firearms Act, under Section 6119, it specifies that any violation under the Uniform Firearms Act that is not otherwise specified is a misdemeanor of the first degree. Because our preemption statute comes under our Uniform Firearms Act, it is a misdemeanor of the first degree for any municipality to regulate firearms or ammunition, even consistently with those laws passed by the General Assembly, yet we can't find a district attorney who will actually prosecute those responsible.
Well, hell, the district attorneys don't even prosecute people on the 5-year minimum when they use a gun to kill somebody.
That's absolutely right. We're seeing a lot of issues with that. And obviously, we've seen a lot of issues in Philadelphia with District Attorney Krasner being, to say extremely light doesn't even start to touch it, his philosophy on how to punish those who violate the law.
Well, I think it's important that our viewers understand that it's expensive to take on these court cases, and Firearms Owners Against Crime, as well as Allegheny County Sportsmen's League, Firearms Policy Coalition, they raise money. So please donate to those organizations. Josh, you've been very good to save us dimes wherever possible, but it's just expensive. I mean, I was educated through you, just the printing. When you get up into those higher levels of courts, there's certain printing that has to be done that's just extremely expensive. And so it's a costly kind of process, but I think it's a necessary one, because we need to try to exhaust all of those boxes, meaning the jury box, the ballot box, all those things before we have to maybe go to that cartridge box.
Yep.
Now, a question I have for you, Josh, actually, I just cut you off, Matt. Do you want to?
Well, I was just going to ask him, as far as the, with COVID and everything, are you finding that any of this stuff's being litigated or being brought up through Zoom, like we're doing this? Do you find that that's cutting down on your, making it easier for you to be able to appear in court through Zoom and cut down on
Plus,
some
you
of the
can use
costs?
an app and look like a kitty cat too, right?
Meow. I'm not a cat, really. I'm not. No, yes and no. So yes, it is making it easier and cheaper to litigate, especially when there would be substantial travel involved, like driving out to Pittsburgh and such like that. Me personally, I would much rather be there in person, like oral argument and that. I mean, you haven't lived until you have 7 to 11 judges all trying to ask you questions at the same time, and the Zoom panels keep popping up different, all talking over each other. That's an experience.
Yeah, that's a good point.
To be honest, they've gotten pretty good with it, but it is not the same fluid type of oral argument that I'm accustomed to and would like to get back to, that we had prior. In fact, I was very hopeful when oral argument was scheduled in the Pittsburgh matter. It was initially scheduled, this was back in October, to be in person. And then the court switched it to virtual. But yeah, we are seeing, and that can be helpful to my clients. And again, I litigate all forms of firearms law issues at the state and federal level, all across the Commonwealth and federally all across the US. So it has been very helpful for clients in remote locations, especially one of the case types that I have with a good number of frequency is mental health relief applications and things like that. So end up getting to all the different counties in the Commonwealth. And when I don't have to travel 8 or 13 hours to get to a court in that for a hearing, that obviously is very helpful to my clients. And thankfully, the courts have been pretty understanding. Also, the Pennsylvania State Police is under direction from the governor to always request that they be allowed to attend virtually. So that kind of gives me an inside track, since they're going to be requesting it, to also say, well, can't my client and I also attend virtually, since the Pennsylvania State Police Attorney will be attending virtually. And the courts have been very, very open to that.
That's good.
So as we move forward into the craziness that we see coming with the democratically controlled legislature, federally speaking, and with Joe Biden in the White House, can anything be done on a state level if a far-reaching executive order is given or some type of legislation is passed that violates the Pennsylvania Constitution?
That's a very difficult question to answer. There are a number of issues. Let me start at the municipal level, because we heard right before COVID, and now it's starting to be resurrected, about Second Amendment sanctuary cities, municipalities, and that. I have grave concern over those, because I believe that it violates state preemption. Agreed. And I believe it's hypocritical for us to be supporting those types of regulations of firearms and ammunition while we're suing municipalities for violating preemption, because they are what we would refer to as anti-Second Amendment ordinances or regulations. So I am not one who's in favor of the Second Amendment sanctuary city ordinances of that nature. And I think we really got to look at that as a community of whether that really benefits our rights, because quite honestly, at best, it's symbolic. It is not, I cannot fathom a local police department actually standing up against the federal government or the Pennsylvania State Police if they come to confiscate
Well,
firearms.
hell, we've even seen that being tested earlier this year. Where were those sanctuary ordinances when Governor Wolf shut down the FFLs at the beginning of the lockdowns and the house arrests?
Right. So that's at the lowest level of government. At the state level, the issue that we run into is that the U.S. Supreme Court has basically, through case law decisions, eviscerated the 10th Amendment. It used to be well understood that only those enumerated powers provided to the U.S. government in the U.S. Constitution were the powers that the U.S. government had. Now, basically, the 10th Amendment is relegated to the back shelf, where it is rare that anything is found to be within a state's rights. And that's extremely disconcerting to me. I am hopeful that based on the current makeup of the U.S. Supreme Court, that maybe we'll see some cases walking the existing precedent back a little bit, and we will see states start to have more rights. But the issue is that the U.S. Constitution's kind of considered the floor, and that a state can provide more rights than what or more protections, I guess I should say, than what the U.S. Constitution provides. But when there's a conflict there, if we're talking about a federal law where the state gives you more rights than what the U.S. Constitution does, unfortunately, unless we see a resurrection of the 10th Amendment, I think those additional protections afforded by the state fall to the federal law that supersedes it. And that's really, really concerning to me. And I hope to God that I'm wrong. But right now, as we sit here, I think that's what would end up happening.
Well, we're
So I don't know that it would really be helpful. And the other thing, just real quick, Matt, before you jump in, to throw in, is some of the listeners may have heard of prior Firearm Freedom Acts that were passed, some saying with regards to National Firearms Act weapons, which are, things like machine guns, short barrel rifles, short barrel shotguns, destructive devices, silencers, category called any other weapons, that states were saying, oh, no, you can't regulate them anymore. And there were people who went out and basically purchased silencers, but didn't register them with ATF, didn't do it in a lawful manner, and were prosecuted successfully, even though they argued, well, hold on, my state passed this Firearm Freedom Act that specifically says I can do this. And the Fed said, that's nice. We're the federal government. This is federal law. We don't care what the state did.
Right. Well, and we're seeing that with medical marijuana, or even, like Colorado. It was an article I wrote for the USCCA. It's, can marijuana, or can medical marijuana and the Second Amendment coexist? And it was called A Smoking Gun. And the whole concept behind that is federal law 4473. If the state could say all they want, but when the federal government says no. But the kicker is, you flip that around, and the whole sanctuary city thing, where you've got the federal government saying you can't harbor a fugitive, being in the country illegally is illegal, right? But then you got states saying, well, no, you come and stay here, we won't prosecute you. It's like, but it's just so freaking upside down, and good called evil, evil called good,
Yeah, you're absolutely right. And maybe that's a good topic to quick touch on, because there is so much misinformation out there, including by the governor here in PA, as well as a number of attorneys, that regardless of your position on marijuana, if you are a medical marijuana card recipient, the use of marijuana is still federally prohibited, and you are prohibited from being able to purchase, possess, and utilize both firearms and ammunition. A violation of federal law is up to 10 years in jail, $250,000 in fines per violation. So that 500 round brick of 22s that you have is 500 separate felony counts. So you need to be aware of that. Also, in that regard, all that is required for someone to be able to lawfully possess both marijuana and a firearm and ammunition would be for the DEA to deschedule marijuana by one level. Right. If it was a Schedule II drug, then a doctor could actually prescribe it. And as long as you have a prescription for it, you would be lawful in being able to utilize it as well as being able to possess and use firearms and ammunition. Now, that just also brings up one quick point I want to make, because so few people realize this. The example I always give is, let's say your spouse hurts his or her back. Doctor gives you a prescription for some Percocet. He or she takes a couple, back's completely fine, still has 10 pills left over, doesn't need them, leaves them in the medicine cabinet. And 6 months later, you injure your back. You say, oh, well, those Percocet really helped my husband, my wife, whatever the case was. I'm going to go grab one. Right now, you just became a prohibited person because you do not have that prescription for that medication.
Right. I go with that with traffic stops and the Fourth Amendment. You know, somebody, well, we can search your car. You don't have any problem with that, right? You have nothing to hide. But then you got your buddy who you gave a ride to, and they popped the Percocet or something, or they popped, some prescription that they have, and it missed their mouth and it fell on the floor. You don't know anything about it. They search your car. Well, now you're in illegal possession of controlled substance, and you can be charged. So that's why I tell people, the Fourth Amendment's there to protect you as a legal law-abiding citizen. It's not for the bad guy. And
absolutely, you never consent to any searches under any circumstance.
Is there anything else that you would like to talk about? Anything that's fresh on your mind that you'd like to get out there?
Sure. Well, there's a couple cases that are pending that might be of interest to the listeners. One in particular is actually out in the Western District of Pennsylvania, and we have a very, very good judge hearing it. It's Judge Stickman. For those who maybe aren't aware, but Judge Stickman was the federal court judge who previously ruled that all of Governor Wolf's COVID regulation, well, not all, but the ones that were before him were unlawful and unconstitutional. Now, that case has been appealed up to the Third Circuit, and the Third Circuit has stayed Judge Stickman's ruling. But the case is before him, and it involves the situation of several plaintiffs who are between the ages of 18 to 21, are ineligible for a license to carry because they are not 21 yet, and are being restricted in their ability to transport firearms even from their home because of 2 states of emergency. We've had a opioid state of emergency in effect. I think it's been since 2017 or so.
It's been a couple years, yeah.
Yeah. And now we have a COVID state of emergency, both of which trigger a state of emergency provision that generally prohibits the carrying or transporting of firearms on any public roads or things of that nature, unless the person has a license to carry firearms.
That's Title 18, 6107?
Yep, 6107, 6108 are all in play, involved, as well as 6106, the general transportation laws. So, we are waiting. The case has been briefed, and we are just waiting Judge Stickman to issue a decision. It could be months from now. It could be tomorrow that we get a decision, but that will be a very interesting case because he has a couple options before him. One is to basically say that the restriction on an applicant having to be 21 is unlawful. And could just easily make them eligible and say, okay, well, now there's no impediment. You can just simply apply for the license to carry. And I don't have to reach the issue of whether the other provisions of the Uniform Firearms Act are unconstitutional. Or he could say, well, I don't think I have that authority, or I don't agree with that. But regardless, these provisions are unlawful, unconstitutional, and could strike down either the state of emergency provision or the transportation law, or both. And in reality, we're actually asking for both, because a lot of people don't realize that the transportation laws here in Pennsylvania are extremely draconian in that it specifies specific places that you must go directly to and from. So you can go from your house to the gun club and back, from your house to the FFL and back. If you, let's say, decide to go to the gun range, you put some lead down range and build up an appetite, and your buddy says, well, how about we stop for a bite to eat on our way home, and you stop and you don't have a license to carry, you just violated the law. And, oh yeah, by the way, that's a misdemeanor of the first degree, where if you're convicted of it, you will be prohibited for life from being able to purchase, possess, and utilize firearms and ammunition. So that's why I say it's so draconian that even to stop for the bathroom, stop for coffee, pick up a friend, anything, if you don't have that license to carry, that is extremely disconcerting because you're basically turning law-abiding individuals who don't know any better into criminals.
What's the intent, right?
Right.
They don't care about the intent. They just want to win.
Right. So, we're going to have to wait and see what happens in regards to that. The other issue that kind of touches on that is cases that I've been involved in. One was in Allegheny County, the others in Philadelphia County, is county sheriffs due to COVID. Well, in Philadelphia, it's actually the chief of police, but basically restricting people's ability to even apply for a license to carry under the guise of COVID. And so Firearms Policy Coalition did sue both the city of Philadelphia as well as the Allegheny County Sheriff's Office regarding those issues, got those departments reopened. The Allegheny case has resolved through a settlement agreement where they implemented an ability for people to submit applications electronically and basically agree to process them in the time frame specified in the law and things of that nature. The Philadelphia case is still pending. We are still going back and forth trying to get it settled. The city hasn't basically enacted a whole bunch of new procedures, let me say, for applicants. In October of last year, they actually had a backlog of 6,500 applicants. They have gotten through that entire backlog by implementing an electronic application process. Now the issue is we are seeing applicants, some are being approved within 72 hours.
Wow.
But on average, most are getting approved within a week, which everyone said is an impossibility to ever get Philadelphia to issue approvals that quick. But now the issue is they are booked out about 3 months in actually providing people with their licenses that have been approved.
Well, they have to do the digital signature and the funny picture, right?
Well, we're talking about that because there is a way we believe that they can submit a digital picture and a digital signature, and the city could just mail the licenses out to people. And
the digital picture and signature is nowhere in statutory law. That's something imposed by Pennsylvania State Police, right?
Right. It does not say, well, the law does talk about having a photograph of the person on the license to carry. It doesn't state that how it has to be, meaning there's nothing saying that the person couldn't submit an electronic digital photo of themselves for it to be used. And
that's how Utah does it. Utah does it that way.
Maryland does the same thing. I submit everything electronically into Maryland. So, there's no reason not to do that. And since the city continually says that the whole reason they're so restricted and shut down and that is COVID, well, then it would make sense to do everything where you don't even need an applicant to come in person to your office. I mean, how can you get any more safe than that? You just simply, process the application, you approve it, assuming they're approved, and then you print out their license to carry and mail it out to them.
We were dealing with that in New York with COVID, where we shut down all of our training. And the first thing I did is I went right to the judges in Onondaga County. And I said, hey guys, can I do the course online? And 2 of the 3 judges were like, yeah, that's genius. You should do that for sure. And then they go, but you have to ask the sheriff. I'm like, no, you're the approving authority. You're the licensing officer based on the law. Oh, but we got to work with the sheriff. I'm like, okay, fine. And so
did you have to get a separate license to be able to talk to the sheriff about this?
Pretty much, right? So I reach out to the sheriff's department and talk to my contact there in the pistol office. He talks to the sheriff. The sheriff says, I won't even consider it unless the judges reach out to me personally. I was like, you got to be kidding me. So I went back to the judges, texted both of them. One of the judges reached out to the sheriff, and the sheriff goes, absolutely not. Under no circumstances is he to teach that course online. And I'm like, you got to be shitting me. Right. So he's just making me run around in circles. He was going to say no right off the get go. He didn't think I'd have the gumption or the balls or the connections to have the judges reach out to him. And I did. And, it's just ridiculous. It's lunacy. And then you've got these counties where we're out right now, somebody to take the class from me. They call the next day to get their appointment to go in to turn their packet in and be basically vetted, if you will. We're looking at almost a year. So November, December is about the time frame, a little less than a year. And then by law, it's 6 months from the time the judge gets it. So they go to the appointment, Sheriffs do the background check, which could take a month, 2, 3 months, whatever they want, whatever they are able to do, because of course it's not a priority for them. That's not their main job, is what they say. And then they turn it over to the judge. And then by law, the judge has 6 months to approve or deny the pistol license. And usually they're doing it in like a month to 3 months. So the holdup isn't the judge. The holdup is the sheriff's getting the appointment and then the background check.
Well, if that law-abiding citizen that applied for that gets jacked up by a criminal
raped or killed
while they're waiting, then every one of those elected
sue.
officials should be held responsible
Mhm.
for it.
Except for they have immunity.
Yep.
Yeah. The elected class is like, hey, come on in. The water's fine, right? No one wants to leave.
And actually what you're describing, Matt, is the situation that existed in Philadelphia before FPC sued. As I said, they had a 6,500 person applicant backlog, but they were scheduling appointments just for people to come in for their initial interview into 2022. And that was back in mid 2020. So, thankfully we were able to rectify a bunch of that, but still there's still issues we're trying to work out to make it better for residents of Philadelphia. And I think even the city of Philadelphia and the gun permit unit has recognized how beneficial some of these changes have been for them, because it does allow them to process them much more swiftly and with less interaction with the public.
Well, one of the last things I wanted to talk about here before we wrap things up, over the last couple of years, we all, like anyone that was a Trump supporter, kind of said, man, if he only serves 4 years, I'm just glad at all the people he got appointed to courts. And that was something that a lot of people said. And he appointed a lot of people to the court system across the country. Are you surprised at how some of the courts, especially the Supreme Court, has been responding to requests for cases and what cases they are talking about or entertaining? Is this a surprise to you, or?
Not really. I think it's stayed pretty much the same. I think Justice Amy Coney Barrett's going to be helpful with a lot of constitutional conservative ideals. Let's be honest, Justice Roberts has not been a friend to the Second Amendment. That's why I think we have not seen a lot of the Second Amendment cases that were appealed up to the U.S. Supreme Court granted what we call certiorari, where basically the court agrees to hear those cases. I believe that Justice Thomas kind of sees himself as the steward of the Second Amendment and protector of the Second Amendment, and he has purposefully ensured that there weren't enough votes to hear those Second Amendment cases, because you only need 4 justices to vote to hear a case, but you need 5 justices to have a majority opinion. And prior to Amy Coney Barrett being nominated and confirmed, without Roberts, while he had the 4 votes to get the case heard, he was too concerned that the case would come down in the other regard, where Roberts would go with the liberal justices of the court and say that this is not something that comes under the Second Amendment.
So in turn, they're protecting the Second Amendment by not hearing those cases that could potentially overturn.
Correct. And I know that's a hard pill for some people to swallow, but I truly believe that that was the situation for the past, 10 years or so, since Heller was decided in 2008, and then we had McDonald. I think that's why there was an understanding that Roberts was not going to be in our court, in essence. And I think we are going to see if that holds true, because I actually have a couple cases currently pending before the U.S. Supreme Court involving what we call as applied challenges, which is basically where someone is prohibited and we argue that as applied to this particular person, not the public in general, but as applied to this particular person, this prohibition or this law is unconstitutional. One was an individual who had committed a DUI, no property damage, no one harmed. As a result of that, he became prohibited under federal law, where he can never purchase, possess, utilize firearms and ammunition. We had filed a challenge in the Middle District. Chief Judge Connor of the Middle District found in our favor, said, yes, this is unconstitutional, went up to the Third Circuit. Based on the 3-judge panel we got, I knew what the outcome was going to be, because two of the judges we got had previously said no one should ever be able to bring in Second Amendment as applied challenge, and they reversed the district court. And then we, luckily, while we still had time to petition for certiorari, Amy Coney Barrett was nominated and confirmed. So that case is up before the court as to whether a nonviolent misdemeanor can ever strip someone of their constitutional right. The other case involves a young lady who made a false statement on a tax return, and as a result, she is prohibited for life. That case was in the Eastern District of Pennsylvania. I did lose that case before the district court. They basically said that a felon can never bring a successful Second Amendment as applied challenge. The Third Circuit basically affirmed that, even though I kind of seem to remember at some point in our history, our founding fathers refused to pay a tax. They didn't believe that divested them of their right to keep and bear arms, and even, I'm pretty sure, took up arms against our English overlords in that regard. Right. But apparently our founding fathers believed making a false statement on a tax return could strip you of your Second Amendment rights somehow, some way. So that case is also up in front of the U.S. Supreme Court. It is possible that the court could, what we call consolidate, basically put both of those cases together and decide in one decision whether a nonviolent misdemeanor and a nonviolent felony can ever strip someone of their constitutional right to keep and bear arms. And if so, is there a possibility to later show through change of circumstances or that it's unconstitutional as applied to that particular person? And if so, what criteria does that person have to show? So that'll be an interesting case. The other case I can say I think will be filed in the upcoming weeks is some of the listeners may be aware of the Binderup decision, which was a Second Amendment as applied challenge. There were actually, before the Third Circuit, two cases consolidated. So one of the plaintiffs was Binderup, the other was Suarez. Binderup had a consensual relationship with an employee. She was, I believe, 17 at the time. As a result, he ended up with a corruption of a minor offense that is a misdemeanor of the first degree. So he became prohibited from being able to purchase, possess, utilize firearms and ammunition. Mr. Suarez, on the other hand, was in Maryland. He did not have a Maryland wear and carry permit. He had a firearm in his vehicle, and he ended up being charged and convicted for carrying a firearm without a license. They both had applied under as applied challenges in the district courts here in Pennsylvania. Both district courts found it was unconstitutional as applied to each of them to deny them in perpetuity. They appealed up to the Third Circuit. Third Circuit affirmed those district court decisions, saying, yeah, they have a right to this as applied determination. And at that point in time, the U.S. Supreme Court declined to hear an appeal by the U.S. government. So those individuals have already had a determination made that it's unconstitutional to deprive them of their right to keep and bear arms. And in fact, that the prohibition that they were convicted of a crime punishable by more than 1 year is unconstitutional to them. Well, those individuals, well, strike that. So in Pennsylvania, in order to be eligible for a license to carry, we have a verbatim clause that says that you can never have been punished by a crime punishable by more than 1 year. So although they can now purchase, possess, utilize firearms and ammunition based on the court decisions, they are being precluded from getting a license to carry, even though the statutory text is identical to that which the federal courts have already reviewed. So I think you're going to likely see in the next coming weeks a Binderup Suarez 2 challenge along with Mr. Miller. Mr. Miller is another Second Amendment as applied challenge that I had litigated where he had forged a PennDOT window tint exemption form. Basically, he had approval from PennDOT to have window tint on his vehicle. This is many, many decades ago. And he got a new car and he was young and dumb. And instead of going through the process of getting PennDOT to issue him a new permit, he just changed the VIN number on the certificate that had already been issued.
Wow.
And that was found out, and that was a misdemeanor of the first degree. District court said, you can't be serious that we're saying that because he altered a PennDOT window tint exemption that he should be prohibited for the rest of his life. So I believe the three of them will be filing a new action in relation to Pennsylvania's licensing provisions that preempt them or prevent them from being able to obtain a license to carry. Because as we reviewed earlier, right now, between the transportation laws that always apply and the states of emergency, they're basically prevented from being able to defend themselves out in public.
Well, cool. I don't want to take up too much more of your time, Josh. I know you're a very busy man, but before we shut down the show here, would you like to share with people how they can read your blog and follow you, and if they need your services, how they can get in contact?
Sure, absolutely. So we do maintain a blog. It's blog.princelaw, PRINCELAW.com. If you go there on the right-hand side, you can restrict the blog articles to certain areas. So we have Pennsylvania firearms law issues, we have federal firearms law issues, all of that nature. So you can kind of restrict the articles that you want to view. You can also sign up to get notice of any new blog articles when they're posted. Also, you can find us at Firearms Industry Consulting Group.com. And you can also call us at 888-202-9297. And that's 888-202-9297. And as I alluded to earlier, pretty much any firearms law issue at the state or federal level, we handle here in Pennsylvania or federally across the U.S. And that is very broad. When you tell people you do firearms law, a lot of times they're like, oh, you do, criminal law. And actually, very little of what I do is actually criminal law. The criminal law aspects of it usually are someone who didn't know that they were prohibited and are now being charged for making a false statement when they attempt to purchase a firearm or obtain a license to carry. Or those individuals who were involved in a justified use of force situation, self-defense matter. But we also handle primarily a lot of civil matters, whether it's representing gun clubs. We do a lot of waivers for them, a lot of specialized bylaws for them that deal with unique issues of being a gun club. Every once in a while, we may have an escapement issue where a round leaves the property and have to deal with that. Do a lot of representation, obviously, of individuals. They may be erroneously denied by the Pennsylvania State Police, or it may be a situation where they are prohibited and want to challenge that prohibition in a Second Amendment as applied challenge. Also do a lot of estate planning, gun trust, things of that nature for individuals. And then we also represent federal firearms licensees, your gun dealers. They may have issues with ATF regarding record keeping. They may have problems with their customers in relation to a sale. It's really quite broad, all the different areas of law that we handle and get into. And people don't realize that when you say that you do firearms law, that it's such a very vast and broad area of the law.
Yeah, and a lot of our viewers are some of my instructors, and Matt's a training counselor too, and has trained a lot of instructors. And Josh, you did my waiver, and that was something, I feel a lot more protected now that waiver has been done by you. That just so much better than what I was using before. I want to thank you for that. But folks can reach out to Josh for that kind of service too.
Yeah, and I signed the waiver, so I know it's very in depth.
You gave up your firstborn child,
It felt like it.
Pretty much.
Like, let me just give you a little bit of blood with that.
But and that's another thing. Those types of issues are constantly changing. As you know, Klint, we actually started, because of COVID, now adding COVID-related provisions, and the law is constantly evolving. And here in Pennsylvania with waivers, there is an ability to allow for a good amount of protection when it comes to training in situations like that. But if they have any issues or questions regarding waivers, like I said, we run the gamut when it comes to firearms law.
Well, awesome. Well, I really appreciate you coming on the show. And I thank you for the work that you're doing here in the Commonwealth and everywhere else that you're doing it.
We need you in New York.
I don't think you can. I don't think you can twist my arm enough to get me to take another bar exam and come up to New York.
We thank you
Awesome.
very much again for coming on the show. And if there's anything that I can do to make your life any easier moving forward, as far as the gun stuff is, well, I even give you a foot rub if you want, Josh.
Ooh, can you
I
hit the
didn't even
lottery?
get that. I stayed in his guest room and I didn't even get that. I've been
No,
in his
no,
guest-
no. Yeah.
Oh,
All right. Well, thank you again for coming
Yes.
on the show, man.
Awesome.
Very
My
much.
pleasure, guys.
Appreciate
You
it.
have a good one. Stay safe out there.
you too.
This is Alpha Landingham with Mantis X. Check us out at mantisx.com. And this is Meet the Pressers with Matt Mallory and Klint Macro.
Meet the Pressers.
There's lots of sponsors that make this show possible, like Mountain Man Medical.
Check them out and give them your business.
This episode is brought to you by Steel City Ammunition. Can't find ammo? We've got it. We'll ship it and our prices are fair. Mountain Man Medical. The right medical training and gear should be accessible to every American. Mantis. Mantis X helps shooters suck less. Meet the Pressers is also generously supported by other fine companies, ranges, and our Patreon members. Thank you.
Thanks for watching or listening to our show.
Make sure to like, comment, subscribe, share, click that little bell thingy so you know when the next episode's uploaded. Support us on Patreon. Come to one of our classes. Host us to come to you and do one of our classes at your location.
And until next time.
Adieu.
Thank you for watching Meet the Pressers.